Thank you, Mr. Speaker. I rise to make my presentation on Bill number 21 of 2022, which seeks to amend the Criminal Offences Procedure Act by amending Section 72 of this Act. As we continue our commitment to the people of Guyana towards legislative agenda, this brings us to specifically consider the amendment to the paragraph in this act which empowered the Director of Public Prosecution to direct a magistrate to reopen a preliminary inquiry with a view to commit a discharge accused. The explanatory memorandum states that by this amendment of Section 72, the repugnance between the Constitution and Section 72, as pronounced upon by the CCJ, is removed. I know much of this has been pronounced upon, has been presented to us by the Honorable Attorney General, but nevertheless, I will repeat some of what has been said before by the previous speakers. Further, Mr. Speaker, according to this memorandum, by amending Section 72, the Director of Public Prosecution may make an application to the Judge of the High Court for a warrant to arrest and commit an accused person who is discharged by a magistrate under the Act. The judge may only grant that application if he or she of the view that based on the evidence before the magistrate that such a course of action is required. Mr. Speaker, we are placed today with the responsibility to conscientiously and without acrimony to discuss and agree to this amendment. It is our duty, Mr. Speaker, to the people of Guyana to objectively present our views for consideration in relation to this amendment, and we must, with the greatest of sincerity, proceed with our respective positions on this amendment. Today, right now, we must eschew all attempts to strain our voices to argue for or against this amendment. There is absolutely no room for that. The time for that has long passed insofar as this amendment is concerned. Today marks the culmination of arguments and legal back and forth which began as early in 2020. In 2022, the Caribbean Court of Justice ruled in the matter. I will, for the sake of clarity, I will repeat the facts of this matter which are stated in the judgment. So, Mr. Speaker, from the judgment, the facts are stated that Marcus Bisram, an accused, was discharged by the magistrate. That is a murder accused. The evidence was heard at the preliminary inquiry. The Director of Public Prosecution, by two separate letters, directed the magistrate to reopen the PI and later to commit Bisram for trial, which the magistrate did. Bisram contended that these directives by the DPP were unlawful and that Section 72 of the Criminal Law Procedure Act, an existing law, empowers the DPP to so direct, and that it was incompatible with the Constitution. He sought orders in relation to these claims. Bisram claimed, Mr. Speaker, that the directions were unconstitutional because Section 72 was contrary to Articles 122 and 144. He also claimed that in any event, the DPP did not precisely follow the steps which is required by law. The CCJ held, which we heard from the Honorable Attorney General, that the best solution is for the National Assembly to make appropriate constitutionally compliant provisions that will cover those circumstances where a magistrate discharges an accused and the DPP is aggrieved. The justices further ruled that the section violated the appellant's rights and was contrary to the rule of law. Mr. Speaker, the ruling came after submissions of arguments by some of the best legal minds, and today I wish to acknowledge my colleague on the other side of the House, Mr. Sanjeev Dattadin, Honorable Sanjeev Dattadin, who represented the applicant, Marcus Visram. So, Mr. Speaker, during that process, the section was not only argued and deliberated upon within the confines of the courtroom. Interest groups, interested members of the public, members of society discussed and disagreed outside of the courtroom. But, however, sir, all of that is over today. There's some of us who will agree with that decision of the Caribbean Court of Justice, and there are some of us who will not agree with that decision. But sir, like I've just said, that is all over now. I'm of the firm view that some minds will remain the same on this issue, but those views can no longer take precedent. We are here today, sir, to ratify the decision of the Apex Court. Our duties for all intents and purposes are pro forma. There are those who will remain in complete disagreement with the court's decision, but that ruling is final. Mr. Speaker, the APNU-AFC coalition is of the view that the court system must remain the repository where concerns are ventilated. But once the Apex Court makes its ruling, there can be no hesitancy, absolutely no hesitancy in implementing the decisions made. So, Mr. Speaker, we have promptly reported for duty to execute our legislative responsibilities. In so doing, it was necessary for all of this to be put into full context, and like I've said, hence the repetition of the history of the case, and for emphasis, excerpts from the judgment was repeated. Today, Mr. Speaker, it is all about fulfilling a legislative and constitutional obligation based on a decision by our Apex Court. Mr. Speaker, even though I unreservedly support the bill, I wish to state that according to subsection 3 of the proposed amendment, it is stated that every application made under subsection 2 shall be made within 3 calendar months of the discharge of the accused person. However, Mr. Speaker, there is no timeline as it relates to the timeline for the magistrate to furnish the DPP upon application, the deposition, that is an authenticated copy of the deposition statements and other documents relating to the PI. So, Mr. Speaker, I foresee an application to the High Court being severely hampered if the submission of the deposition request is not made in a timely manner by the magistrate. So, Mr. Speaker, assuming it is provided to the DPP on the last date of the expiration of the 3-month period within which an application can be made, I think the point has been made. So I humbly ask the Attorney General to consider including in the amendment a proposed timeline in this regard. On that note, I wish to close by expressing my unreserved support for the decision of the CCJ, and I wish to publicly commend and for the records the Attorney General for his continued dedication and efforts at reforming, modernizing, and restructuring a sector that I am very, very much passionate about. It is my fervent hope that all bills and motions brought to this honorable House will receive unambiguous and clear representation and discussion that the people of Guyana, and that is what matters, that the people of Guyana will benefit from our deliberations. With that, thank you, sir.